This is the August 9th, 2012 meeting of the Zoning Board of Examiners and Appeals. Would you call the roll, please?
Timothy Big,
Here.
Dean Cars,
Here.
Jeff Ron,
Here.
Joshua Fink, Ann Denny,
Here.
Kate Williams,
Here.
Dale Patrick,
Here.
John Dunham,
Here.
Deanna Willard.
And before we go further, I believe Ms. McConnell, Erica McConnell is here this evening, had a quick statement to make.
Thank you. Mr. Chair and members of the board, I just wanted to come and introduce myself. My name is Erica McConnell. I'm the new manager of the current planning section, previously known as the zoning and platting section. I've been in the planning department for 9.5 years. I spent my first 8 years working in the long-range planning section on the Title 21 rewrite, spent 1.5 years in the transportation planning section, and now here I am in current planning. Just wanted to put a face to my name, let you know that I'm available anytime if you'd like to contact me if you have questions or issues. Other than that, I leave you in the very capable hands of the staff. Thank you.
Thank you, Ms. McConnell. We have minutes for approval this evening, minutes from the June 14th and June 12th public meeting. Has everyone had a chance to review those minutes? Does anyone have any comments on those minutes? I do have a couple comments. I believe on the June 14th minutes, those should reflect my absence and Vice Chair Dunham's chairing the meeting, and on the July 12th minutes, that should be stricken in the absence of Chair Dunham, Vice Chair. As I mentioned to Ms. Graves, I want my title of Chair for the record. So, are there any other comments on those minutes? Could I have a motion for approval? Ms. Denny, thank you. Mr. Patrick, thank you. Is there any opposition to approval of the minutes? Seeing none, the minutes are approved. And for the record, Ms. Willard, you are now in attendance, yes?
I'm here. Sorry about that.
That's all right. Thank you. Which moves us on to agenda item C, special order of business. Disclosures. Are there any disclosures by any of the board members this evening? Mr. Dunham.
Mr. Chairman, I was absent from the July 12th meeting, so I won't be voting on any of the resolutions from that meeting.
Thank you, Mr. Dunham. Are there any other disclosures?
I also have 2 disclosures.
Yes, Ms. Willard.
The first one is on case 2012-100. I'd like to disclose that my firm currently has a contract with the petitioner, Cook Inlet Housing Authority, but I'm not involved in this case, and I have no financial or private interest in the case. I feel I can act impartially before the board. For the second case, 2012-101, I do have a private interest with the petitioner's design team, and it poses a conflict of interest impacting my participation in this case, so I would request to be recused from that.
Thank you, Ms. Willard. I would entertain a motion from the board. Maybe we will handle those separately then. Could I have a motion from a board member regarding Ms. Willard's participation in 2012-100? Mr. Vague.
Mr. Chairman, I move that we direct Ms. Willard to participate in case number 2012-100.
Thank you, Mr. Vague. Ms. Williams, you've seconded that?
Yes.
Thank you. Is there any discussion from a board member? Any opposition to that motion? Seeing none, Ms. Willard is directed to participate in case 2012-100 with regard to case 2012-101. Mr. Rowan.
Thank you, Mr. Chair. I direct Board Member Law to participate in case number 2012-101.
Thank you, Mr. Rowan. Ms. Williams, you've seconded that?
Yes.
Thank you. Mr. Rowan, she's requested to be recused from that case.
Understood,
Do you have
Mr.
any
Chair.
discussion?
I don't. Just in reflecting that, Ms. Laud's comments state that she would have a conflict, and I will not be voting for the motion.
Thank you. Is there any other discussion? With that, we probably need to vote on that one, because I'm assuming there won't be. That motion fails, so Ms. Laud is recused from hearing case 2012-101, and at the time we hear that case, we'll ask you to step out to the assembly, outside the chambers for that case. And then lastly, I believe, Ms. Laud, you were absent last month, so have you had a chance to listen to the minutes on Granicus, or will you be excusing yourself?
I will excuse myself from those as well. I apologize for not mentioning that.
Sorry, you had a full...
From the July 12th meeting, I'll be abstaining from voting on resolutions under the consent agenda.
Thank you, Ms. Laud. Are there any other disclosures this evening? Any of the board members? Seeing none, that moves us on to on the consent agenda, resolutions for approval. We have 5 resolutions before us this evening. Are there any comments on, would anyone like to pull any of the resolutions from the consent agenda? Seeing none, is there any opposition to passage of the consent agenda items? Do we want them? I guess we still need a motion to approve. Oh, it all passed. That was well done. All right. Mr. Vig, he came in at the end, and Mr. Ron seconded. So thank you both very much.
Yes.
So with that, the consent agenda is approved. We have no appearance requests, unfinished business. There are no items on the regular agenda, which brings us to our public hearings this evening. Before we hear our first case, I'd like to read the order of business for variances. The chair shall introduce the variance and explain the procedure to be followed. The variance case number and the name of the applicant shall be read into the record. The board shall hear and rule on any objections to the sufficiency of notice. The board shall hear a brief staff presentation outlining the variance, not to exceed 10 minutes. On conclusion of the staff presentation, the board members and the applicant may then direct questions to the staff through the chair. The applicant shall give his or her presentation not exceeding 10 minutes. Throughout the proceedings, the burden of proof rests upon the applicant, who must convince the board by a preponderance of the evidence that the variance should be granted. On conclusion of the applicant's presentation, the board members and the staff may then direct questions to the applicant through the chair. The hearing shall then be open for public testimony. Each person has 3 minutes. All persons who testify may be questioned by the board, staff, or the applicant. On conclusion of the public testimony, the staff, followed by the applicant, shall have the right of rebuttal, 3 minutes each. The board shall proceed to develop oral findings and conclusions with regard to the variance and disposition of the variance. The staff shall reduce the oral findings and conclusions to writing for subsequent adoption by the board at a later meeting. The matter then rests with the board, and the chair asks for a positive motion from the board. Our first case this evening is 2012-080, and we have received the 2012-080 petitioner Theodore Mallett, a variance for an encroachment of the required yard setbacks. We've received a request to postpone for this case by the petitioner, and there's been a request to postpone the case indefinitely. I'd request a motion from a board member to postpone this case indefinitely. And Mr. Vig and Mr. Ron, you're still on the screen. Is that correct for that motion? Thank you very much. Is there any opposition to the postponement of that case? Seeing none, case 2012-080 is postponed. Our next case is 2012-093, the applicant, Scott Kirk. He's indicated he's present this evening. Who from staff will be presenting this case?
I will.
Thank you, Mr.
Chair.
McLaughlin. Would you provide us with the sufficiency of notice, please?
Thank you. On July 18th of this year, there were 48 public hearing notices mailed. As of the writing of the staff report, there were no responses received from the public or the Girdwood Board of Supervisors.
Thank you, Mr. McLaughlin. Would you proceed with your presentation?
Thank you. The petitioner requests variances from two sections of our land use code. First one is dimensional standards to allow an existing 864 square foot single-story detached garage to encroach approximately 2.7 feet or 13.5% into the required 20-foot front yard setback in the GR1 district. Also, the petitioner requests a variance from accessory buildings to allow the garage to be located approximately 2.7 feet from the house. This regulation states no separate accessory building shall be erected closer than 10 feet to any principal structure on the lot or an abutting lot or tract. Standard number 1 does not appear to be met for either variance. There are no exceptional physical circumstances of the land. There are no streams, wetlands, or slopes. The lot has the same rectangular shape and size as other lots in the same neighborhood. However, this is a corner lot. There's a minor slope, a slight slope northbound of the property from the Alyeska Highway headed in the other direction across the property. The lot contains approximately 11,993 square feet, which is 1,593 square feet larger than the minimum required lot area in the GR1 district. This is a corner lot because it borders Danish Circle and the Alyeska Highway. Standard number 2 does not appear to be met. The front yard encroachment, there are no physical circumstances of the land which prevent the owner from having a garage. The lot has sufficient space in the front yard, primary front yard, to build a garage and meet the required 20-foot front yard setback. However, the garage is a common right of enjoyment in the neighborhood. In regards to the building separation, there's ample space on the lot for a detached garage. The building separation violation is a result of construction without a land use permit. It appears that the garage was built, decades ago, maybe 30 years ago, but it is not eligible for non-conforming rights. In regards to standard number 3, neither variance appears to meet the standard. There are no peculiarities of the lot. This is essentially the same lot as others in the same zoning district. The need for the variance is the result of the petitioner's desire to keep an existing garage in its current location. One of the previous owners built this 864 square foot detached garage without a land use permit. In regards to standard number 4, the standard is met. And standard number 5 is also met. Standard number 6 is met. And standard number 7 appears to be partially met for both the front yard encroachment and the building separation violation. In regards to the front yard encroachment, a garage can be located on the property without encroaching into the front yard setback. However, the small encroachment may be considered de minimis. In regards to the building separation, a garage can be built on this lot and maintain the 10-foot separation from the house. This is a modest size garage, and in the proposed land use code, which is not adopted yet, this 10-foot separation, building separation, may be removed from the code. The department finds that standards 1, 2, 3, 4, and 7 do not appear to be substantially met for either variance and therefore recommends denial of both variances. If after a public hearing the board finds that all 7 standards have been substantially met for either variance or both variances, then approval should be subject to conditions 1 through 4 on page 6 of your packet. There is an as-built to the property on page 7, and a zoning map on 8, a aerial photo on page 9, The petitioner's application begins on page 10. Now, the conditions of approval, if the board finds justification for that the standards are met and approves either of the variances, standards number 1 and 2 deal with each of those variances separately. So depending on how the board votes, they will have to maybe tinker with those conditions 1 and 2 to delete one or to approve both. One will just have to read those. With that, I'd be happy to answer any questions. Thank you.
Thank you, Mr. McLaughlin. Are there any questions of staff by the board? Mr. Dunham.
Yes. What are the setbacks for the GR1 zoning district?
I believe it's, well, in Girdwood, they're a little tricky. Let me go to the report. I believe that the 20-foot front yard setback, 10-foot secondary front yard setback, and then 5-foot side yard setbacks. There is no rear yard. I'm going to double check that right now in the code. And also, Girdwood has this, the Girdwood code is separate from the Anchorage Bowl code, and it has a rule about how you can add to, if there's, I'll have to read it.
I'm just trying to figure out where the front yard encroachment is.
Yeah, on page 49, GR, Red Zoning District. Oh, I'm sorry, it's the GR1 and GR1 Alyeska Highway Mixed Residential District, dwelling, multifamily, single-family, attached, single-family detached. So there's a 20-foot front yard setback, 10-foot side yard setbacks. Along Danish Circle, that's the primary front yard. That's a 20-foot front yard setback. Along Alyeska Highway, that's a secondary front yard, which is would mean it's 10 feet. And then the two side yards are each 10 feet. There's a subscript, or I forget the terminology for that, but there's a caveat has to do with if you subtract from one yard setback, it can be added to the other. But that wouldn't apply in this situation.
Okay. Thank you.
Thank you.
Mr. Patrick.
Thank you. Mr. McLaughlin, I have a question. You state that item 4 is not met on the front page and in the recommendations, but on the findings it is met. Can I get a clarification on that?
Oh, let's see. Thank you, through the chair, Mr. Patrick. Mr. Patrick just pointed out an error in my presentation and what's written in the staff report. So the staff report says under department recommendation, the department finds on page 5, the department finds that standards 1, 2, 3, 4, and 7 are not substantially met. That's wrong. 4 is met. You should delete that from the written record. Standard number 4 is met. So standards 1, 2, 3, and 7 do not appear to be met. Standard 4 is met. Thank you, Mr. Patrick.
Thank you. I have another question also. Is there access allowed to this lot off of Alyeska Highway?
No, sir. There is no permitted access.
Thank you, Mr. McLaughlin.
Ms. Wad.
Yes, I was wondering, in the proposed, if approval goes ahead, item 4 indicates resolved with the Municipal Traffic Division the width of the driveway and corner clearance distance, which would indicate to me that it currently does not meet that requirement. What is that corner clearance that's required?
Through the chair, Ms. Vlad, I spoke with, after the comment came out, traffic plan review believes that believes that the dimensions are met, but would like to sit down with the petitioner and to scale this. And we weren't able to complete that prior to this meeting. So I think that condition number 4 is just sort of a double check thing, but should not be interpreted that the driveway doesn't meet the standard for Girdwood driveway corner clearance.
Okay, thank you.
Mr. Vig?
Thank you. Mr. McLaughlin, I think in the reading of your summary of the request, there may be a typographic error in the second paragraph where it says the garage would be allowed to be 2.7 feet from a house, but I think it's 5. The 2.7 is for the front yard setback. Is that right? And since it was read into the record, I think it would be probably good to straighten that out.
Thank you, Mr. Vig. So, the staff report has an error in saying that the separation between the principal structure of the house and the garage is 2.7 feet. That should say 5 feet, and the requirement per the zoning code is 10. So that's a 50%, but 50% encroachment if we think of it that way. Thank you.
Did that answer your question, Mr. Vig?
Yes, thank you.
Thank you. Mr. Ron?
Thank you. Through the Chair, Mr. McLaughlin, regarding your narrative in response to Standard 7 and your statement that encroachment appears to be de minimis, if you could refresh my memory, what's the threshold for application of that de minimis in this case?
Are you through the Chair, Mr. Ron, are you referring to the administrative approval?
If that's in fact what you were referencing with the statement, yes.
The de minimis statement, staff used that word to say that generally it appeared in the view of the department that the encroachment was not great. 2.7 feet into a 20-foot setback did not appear to be a visually noticeable and dramatic encroachment. It was more of just a general statement. As Danish Circle, the road is actually even further from the property line. There's 60 foot of right-of-way for Danish Circle, so if the road is only 24 foot wide within that 60 feet and it's on the center line, then the road would be, more than 20 feet from the actual structure, but we have to measure from the property line, which may already start quite a ways from the built street. So it appears de minimis, but I don't have a way of qualifying that statement.
Thank you.
Are there any other questions of staff by the board? Seeing none, could the applicant come forward, please? Could you state and spell your name for the record?
My name is Scott Kirk, S-C-O-T-T-K-I-R-K.
Thank you, Mr. Kirk. You have 10 minutes for your presentation, and again, we must find that all 7 standards are met, so if you can make sure that as part of your presentation you
I'd like to thank the planning and zoning staff for their help. Helping me get this arranged, and also like to thank the variance board for your consideration. I'd like to respectfully disagree with the standards that are not met, 1, 2, 3, and 7. In regards to 1, I believe the fact that it's a corner lot left me limited access for a garage. And in speaking with the previous owner that had built the garage, to the best of his knowledge at the time, the setback was 15 feet. And that was one reason it was put where it is. The other reason, he was trying to preserve these several very large old-growth spruce trees that are still there right next to the garage. Speaking to the number 2, again, the corner lot and the placement of the house, it really just didn't leave another place to put this garage. And It would create an undue financial hardship on me if I was required to alter the position of that structure, and I would have to remove several of these very large spruce trees. And I was unaware of this violation even through my financing of it, which financing usually picks stuff up like that if you're in a setback. So this was the first I had known about this. Speaking to number 3, the structure was built where it is 25 years ago. Again, as I say, to the previous owner that built it, to the best of his knowledge, the zoning rules were different at the time that he built it. And then speaking to number 7, the current property has, the structure has been where it's at in its present footprints with no complaints or anything from any of the neighbors. And what predicated me getting this was I was just lifting my cabin up 1 story. It didn't change the footprint of the existing place. Again, moving the garage would require removing several large old-growth spruce trees, and it may or may not be too close to an overhead power line. This doesn't really show on my as-built, but the overhead power line is right near my property line there. That's all I have to say, and I would relinquish any of my remaining time to any questions or rebuttals.
Thank you, Mr. Kirk. Are there any comments from any of the board members? Mr. Vig.
Thank you, Mr. Chairman. Mr. Kirk, would that power line be located parallel to Crow Creek Highway on the southeast lot line? Is that about where that is?
Yes.
And do you have a power pole on your property that supports that power line?
There is a power pole, I believe, at the very far end of the property, and it goes right over a grove of trees that sit right in front of my house that, they have to cut down every once in a while to stay out of the power lines.
Okay, thank you.
Are there any other questions of the applicant by the board? Mr. Dunham.
Yes, Mr. Kirk, you said that you'd found out about this when you went in to get a permit to raise your house. And they had no record of a previous permit on the property.
As far as for building that shop,
Yeah.
the garage?
Yeah.
No, I don't believe there was one.
Yeah. Did you have any plans to connect the 2 buildings?
No, I haven't. I had considered that, and then I spoke with the Girdwood Fire Chief regarding that, the separation issue. I think that was one way to get around it, was to connect the buildings. But the way it was explained to me, the separation ruling was made as a fire issue, and I have a letter from the fire chief saying he didn't have any problem because there's access from 2 different sides of the building, one from Alyeska Highway and one from Dana Circle.
Okay.
And there should be a letter in your
Yeah, I think I saw it, so I appreciate that. Thank you.
Are there any other questions? Just one question, Mr. Kirk. You've indicated raising, I thought you had said the log home you would want to raise, but which of these structures are you?
It's the cabin, not the garage.
So you're intending to raise the cabin
Yes.
then, not the subject variance
Right.
structure? Okay, thank you. Are there any other questions? Does staff have any questions?
Thank you, Mr. Chair. The letter from the Girdwood Volunteer Fire Department that Mr. Dunham was referring to, and the applicant, Mr. Kirk, is on page 14 of your packet. Girdwood Fire Department says that they have no objection to the building separation. They don't see that as a fire safety issue. Also, a couple pages further on page 17, we have the building safety. One of the supervisors in the building safety division says that the fire separation is not an issue for building safety, for the building safety division. That's all. Thank you.
Thank you, Mr. McLaughlin. Ms. Williams, you indicated you did have a question.
Yes, thank you.
The large trees that you had referenced, on page 7 of the packet, there's a as-built. Could you let me know the location of the trees around the garage?
And Mr. Kirk, just for the record, could you speak a little bit louder into the microphone so we can get your response? Thank you.
Okay, on the Crow Creek Highway, Alyeska Highway side of the garage, right about where the 36 is written to show the length of the garage, there's one spruce tree right there, and it's a really, really big one. And then on the other side, right about in the same middle section of the garage, there are two that have interconnecting roots between them right there. So they're on both sides of the garage.
Great, thank you.
Are there any other questions of the applicant by the board? Seeing none, you have a seat. We'll open it up for public hearing. Is there anyone from the public wishing to testify? Anyone at all? Seeing and hearing no one, the public hearing is closed. Does staff have any rebuttal?
No, Mr. Chair.
Thank you. Mr. Kirk, there's no public testimony, but you have 7 minutes and change for rebuttal. Anything? He's indicated he has no rebuttal. With that, the matter rests with the board. Could I have a positive motion from the board member, please? Ms. Williams.
In case number 2012-093, I move we grant a variance from AMC 21.09.060B, Table 1, to allow a garage to encroach approximately 2.7 feet into the required 20-foot front yard setback, and grant a variance from AMC 21.45.030B to allow a garage to be located approximately 5 feet from a house, subject to conditions 1 through 4 on page 6 of the staff packet.
Thank you, Ms. Williams. Mr. Dunham, you indicated you would second that? Thank you, Mr. Dunham. Ms. Williams, would you speak to your motion, please?
Yes, thank you. I do tend, or am leaning towards supporting this motion at this point, but I am interested to hear the views of the other board members. For Standard 1, I do believe that standard is at least partially met for both variances due to the fact that the property is a corner lot and also is located along Alyeska Highway, which limits access to the property. Standard 2, I also believe that standard is at least partially met for both variances, again, for the same reasons as Standard 1, because of the fact that the property is a corner lot and its location along Alyeska Highway. And for both of those standards, too, the location of the trees which surround the garage makes it locating the garage without having to remove those trees very difficult. Standard 3, I agree that, or I believe that standard is at least partially met as well. The encroachment, the petitioner had no knowledge of that at the time of purchase, nor did that encroachment come up during sale, so it doesn't look like it was recorded at all. And removing that, the trees, removing the garage would create quite a hardship, and doesn't appear to me at least that on the property another garage could be built on a different location. And I agree with staff on standards 4, 5, and 6 that they are met. And standard 7, I agree that, or I believe that standard is met. for both variances. I do agree with staff that the 2.7-foot encroachment into the front yard is de minimis, and the building separation issue I don't really think is an issue due to the fact that the fire chief has approved the separation, a separation of less than 10 feet. So for those reasons, I'm at this point leaning toward supporting my motion.
Thank you, Ms. Williams. Mr. Dunham.
Yes, Mr. Chairman. I also intend to support this motion and concur with Ms. Williams' comments. And I'd like to add that the extraordinary amount of time that's passed since the addition of this garage to the property and the fact that no real problems have occurred demonstrates to me that this is really a de minimis variance, that there have been no issues other than the fact that the petitioner came in to raise the cabin on the property and found out there were a couple of zoning exceptions on the property. So I intend to vote for it.
Thank you, Mr. Dunham. Are there other comments from any of the board members? Seeing none, we will vote. I will indicate I intend to support the motion as well, concurring with the findings of Ms. Williams and Mr. Dunham and staff. Please vote. That motion passes by a vote of 8-0. For those in attendance, in order for a motion to pass, it must receive a majority of votes from the fully constituted board. The fully constituted board consists of 9 members, so for any variance to pass requires a vote of 5 votes in favor. That motion passes by a vote of 8-0. I do need to read for the record, every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. That brings us to our next case, which is 2012-098. The petitioner is Randall Larkowski. Is the applicant here? They've indicated he's in attendance. Could staff provide us with the sufficiency of notice, please?
Thank you, Mr. Chair. 80 notices were mailed on July 18th. 1 notice was returned unclaimed. 1 notice was returned opposed to the request. The petitioner submitted 3 letters in support of the request. 2 letters came from neighbors that adjoin both the east and west property boundaries, and a 3rd letter was returned from a neighbor directly across Iliamna Avenue from the petition site. Today we received another comment in opposition to the variance request, and that was laid on the table tonight for the members of the board. The case before the board tonight is a request to allow construction of a garage that is 20 feet by 32 feet, addition that to the northwest side corner of the existing dwelling unit that would result in a 4.8-foot encroachment into the 20-foot front yard setback. The property is zoned R1A. The site is Lot 21, Block R Park Subdivision. It was platted in 1956, and the lot contains 8,400 square feet. It's located on the south side of Iliamna Avenue, and Iliamna Avenue provides the only vehicular access to the property. The lot was developed with a single-family dwelling in 1958. According to property appraisal records, a garage was not part of the development. There has never been a garage on this site. It was zoned R1 in 1959, so it was platted and developed before the implementation of zoning. And then it was rezoned in 1965 to R1A. In reviewing the 7 standards for granting a variance, it does not appear that standards 1, 2, and 3 were met. There do not appear to be any physical characteristics that would limit the development of the lot in comparison to other property in the surrounding neighborhood. The lot is level. It is not impacted by streams, major drainage ways, or wetlands. It is not in an avalanche hazard zone, but it is in a very high ground failure risk in the event of a seismic event. Block R of Park Subdivision was not platted with alleys to provide a second vehicular access to the lots, so the only vehicular access right now is from Iliamna Avenue. There is an option available to the petitioner, which is to extend a driveway along the east property line and construct a garage at the rear of the dwelling. However, it would involve removal of trees along the east property boundary. I did include as an attachment to the packet a 2009 aerial photo of the property and the surrounding neighborhood. You can see that it is a very old neighborhood. It's one of the older neighborhoods in Anchorage. It is well developed and it has substantial stands of old growth vegetation. It would require the removal of most of the trees along the east property boundary. It would eliminate privacy for not only the petition site, but for their neighbors along the east property boundary. And the neighbor along the east property boundary did submit a letter of non-objection to the variance request. As there were not special physical circumstances affecting the property, it does not appear that the variance is a result of special conditions. Standard 4 does appear to be substantially met. The most affected neighbors have written letters of support. The 4.8-foot encroachment would be difficult to detect due to the depth of the undeveloped right-of-way and similar development that has occurred along Iliamna Avenue. The petitioner's representative did provide a view of the streetscape that did show that there is substantial undeveloped right-of-way. There already is a 35.5-foot front yard setback, and with the undeveloped right-of-way, although it cannot be counted as part of the front yard setback, but from a visual streetscape point of view, it would be very hard to detect that this garage is encroaching any more than other buildings that exist along Iliamna Avenue. Standard 5 does appear to be substantially met. It would not affect the health, safety, and welfare of the adjoining neighbors. The subdivision was platted with somewhat larger lots. They range from 9,129 square feet all the way up to 15,735 square feet. So if the garage were to be constructed, it would not adversely affect the adjoining neighborhood in terms of light, air, and open space of the adjoining neighbors. Standard 6 and 7 do also appear to be met. It is the required minimum variance. According to Title 21, the minimum depth of a parking space for a 90-degree parking angle is 20 feet. The depth of the encroachment or the depth of the garage is 20 feet deep, resulting in the 4.8-foot encroachment into the front yard setback. They could not really build a garage that is 5 feet shorter because they would not be able to park a vehicle within that garage. However, because all the standards did not appear to be met, the department must recommend a denial of the requested variance. However, if at the conclusion of the public hearing, the board does find that all the 7 standards have been met, 2 conditions on page 9 are provided for the board's consideration. Thank you.
Thank you, Ms. O'Brien. Are there any questions of staff by the board? Mr. Ron?
Thank you. Through the chair, Ms. O'Brien, I have a question regarding your response to standard number 7 in your application of Table 1 in EMC 211-45.080X.9. If my understanding is correct, it, as stated in Title 21, shall apply to all required off-street parking. Is off-street parking required for this lot?
Through the chair, parking spaces are required for a single-family residential, but I just cited that as the standard for a parking space as it would apply to a garage, that the dimension is 20 feet, and that the proposed dimension of the garage was the minimum standard based on a typical parking space.
Thank you, Ms. O'Brien. I'm just getting hung up on requirement versus option for the parking on site. So thank you for responding to the question.
Thank you. Are there any other questions of staff by the board? I do have a question, Ms. O'Brien. We have an 11 by 17 aerial that was handed as part of our packet, and I'm not sure if this was by the applicant or not, but do you have a copy of that aerial?
Mr. Chair, yes, I provided that.
Oh, thank you. Okay. The lots, the 2 lots immediately to the east of the petition site, there's not a scale on this, but it appears to my untrained eye that those 2 lots may encroach into the 20-foot setback. Realizing that each case needs to stand on its own merits, are you aware if any variances have been granted for either of these lots?
Mr. Chair, I did not investigate those 2 properties because I have no idea when those structures were built, if variances were needed, if they have non-conforming rights attached to them. I basically concentrated on the petition site for which the variance was requested, and it seemed as though there were varying locations where principal structures were constructed, and the petition site was constructed toward the front of the lot. And it should be noted that when I looked at the larger grid map, many of the lots, this is a very old subdivision done in 1956, subsequent subdivisions to the west and to the east have alleys, and they do have access from the rear of their lots. But that is not the case in Block R of Park Subdivision. There's lots of blocks in Park Subdivision, but there were no alleys platted with this. But the subdivisions directly west across, forgive me, I forget the name of that street, but directly across the street, the main street, those lots all have alleys, and they have an option to have a detached garage in the rear that's accessed from an alley, which provides more flexibility for those lots than for the lots in Block R. But I did not, to answer your question, did not investigate those lots.
Thank you, Ms. O'Brien. Are there any other questions of staff by the board? Seeing none, could the applicant come forward, please? Could you...
Can we have this thing turned on?
Yeah. We need We'll turn that on. Can you state and spell your name for the record, please?
Sure. Good evening, Mr. Chairman, Commissioners, members of the board. My name is Tom Dreyer. I'm with the S4 Group, and I represent the petitioners tonight, Randall and Tula.
Thank you, Mr. Dreyer. And just
Okay.
for the record, they are in attendance as
Here
well.
in the front row here.
Indicated they
Yeah.
acknowledge you as the representative. Thank you, Mr. Dreyer. Can you proceed with your presentation? And again, you have 10 minutes.
Okay.
And we must
Like
find
that.
all 7 standards are met.
Right, I shouldn't take that long, but I'd like to reserve 2 minutes just in case. I'll focus on the finding number 1, talking about the physical circumstances in this particular case. This is a very old area, very highly desirable, well landscaped, with lots of old growth trees. In 1964, the earthquake severely affected many of the houses in this area, with land movement in the northerly direction of from 0 to 3 to 5 to 10 feet. I cannot ascertain exactly what the earthquake movement was on this particular lot at that time, but the land 100 feet or so to the, sorry, this isn't coming over that well, but the land about 100 feet to the west of this lot moved about 10 to 20 feet north, and at the same time lost about 20 feet in elevation. And what that did is it made this road, instead of a thoroughfare, it turned it into a cul-de-sac. And the road was never rebuilt, and it's been dead-ended since 1964, and no plans have ever been made in the last 48 years to ever replace it. So now this road only services about 10 houses. One very interesting thing, that if you look on your packet, page 4, there's a drawing showing, mainly just it's drawn just to show the existing pavement on the road and then the setback from, say, the back of curb. Well, the right-of-way on the north side of Iliamna Avenue in this section, from the cross street to the east to this kind of this cul-de-sac to the west, is only 25 feet deep. So you have a 25-foot right-of-way on the north side, and you have a 30-foot right-of-way on the south side. So if the south side was 25 feet and matched the north side, we wouldn't be standing here because there'd be no need for a variance. In other words, everybody along the north side of the street here can build the same distance that we're applying for the variance for. It would be the same distance from the center line of the street, and there'd be the same distance between, say, the back of curb and their house or garage or whatever it may be. Except for the corner lot on the north side of Iliamna to the east, all houses commonly enjoy 2-car garages that are front on Iliamna. And 2 of the other garages are even closer to the property line than our request. Along the south boundary of Iliamna, the two lots to the west and the two lots to the east of this, the garages are set back 12 feet, 31 feet, 18 feet, and 15 feet. So our request of 15 feet is going to fit in pretty well with what everybody else has going on in there. And as far as the other garages, they're on a corner, so and as we all know, a corner can be half of the setback. So if we go this way,
Do you like that zoomed out, Mr. Dreyer? Would that help, or are you? We're okay, I just wasn't sure.
are you guys okay?
We're okay. Are you okay?
Yeah. So they could actually be at 10 feet because it's a corner, because it'd be 20 feet on 4 Acre and then 10 feet on Iliamna. The newer house has been built towards the east here is only 12 feet from the property line. But again, it's also a corner because the west boundary of this lot goes around to that road to the west. There's so many other variances needed on this street. The city needs one for the proper turnaround. There's retaining walls into the right-of-ways. There's driveways that are twice as wide as code allows. There's other garages too close to the front setback. And two of the houses on the end are built with no constructed physical street frontage, because that's where it drops off about 20 feet. They're earthquake affected. Yet, after saying all that, it's still one of the most beautiful little streets in Anchorage. It's a very livable, highly desirable neighborhood. And none of the above hardships are self-imposed. As concerning a driveway or trying to put a garage in the rear, putting a driveway to the rear of the lot is just infeasible. It would be quite ugly, cut too many old growth trees down, be too narrow for one. It's only, I think, 12 feet on that east side. It would add too much pavement and just would be undesirable for the neighbors. It would be far more attractive to have the owner's cars parked in an aesthetically pleasing, architecturally designed garage than parking outside in a driveway. It's just a win-win situation for everybody in the neighborhood. And we have letters from both neighbors, on one to the east and one to the west, and then also the neighbor directly to the north, if I'm correct. Yes. And with that, I'd like to close my introduction. Do you want to add anything, Randy, at this point? We can do it in rebuttal. Thank you. I'll take any questions.
Thank you, Mr. Dreyer. Are there any questions of the applicant by the board? Ms. Walad.
Yes, through the chair, I'd like to ask the petitioner's representative, the drawing that you just pointed out on page 4 shows the garage fronting the street, as opposed to that. Is that where you're headed?
This is what they prefer to do, correct? Yeah, this drawing here was mainly for just showing the dimensions back there. And
okay.
that guy got a little out of hand there.
I would commend that approach over the other, as far as the aesthetic and what it does to the street. So, thank you.
Are there any, Mr. Vig?
Thank you. Through the chair, Mr. Dreyer, kind of following up on Ms. Vlad's question, the drawing on page 4 of the packet depicts what looks to be a 3-car garage. What's the intent of your proposal?
The intent is the 2-car 20 by 24.
20 by 24?
Yeah, sort of little artistic leeway on that one there. Not
So
on 4, I apologize.
So the amount of encroachment is reduced 8 feet in the east-west direction from what's shown in the staff packet on page 3 then? Which depicts a 32-foot.
Randy, you want to speak to that?
Could you state and spell your name for the record before
My name is Randall Larkowski, Larkowski.
Thank you.
We're requesting 4.8 feet towards Iliamna Street. we're looking for a garage that's 20 foot deep from the front of the house towards the street, entering in from the east. The depth is 24 feet, so we'd have a little bit extra space for freezers, et cetera. And a curved driveway. The 8 foot, I believe, is the water easement, and that shouldn't be affecting what we're looking at.
Well, I'm just trying to arrive at what the size of the structure.
The structure is intended to be 20 foot wide, or 24 foot wide and 20 foot deep.
Okay.
So it'll be a two-car garage.
It'll be exactly a 2-car garage.
Okay.
So I'm going to just, for my simple mind, on page 3, you have page 3 of the staff packet. Okay, the garage that's showing is, there are two dimensions, 32 feet and 20 feet.
Right.
What are you saying that dimension that shows on our packet is 32 feet? What should that be?
The 32 feet should be 24 feet.
That should be 24.
Yes, sir.
And the 20 foot stays 20 foot.
Correct.
Thank you.
Then the garage door will be on the 20 foot side.
Okay. Thank you.
Yes, sir.
Mr. Dunham?
Yes, Mr. Chairman. Mr. Dreyer, I was interested in your discussion about the right-of-way dedication. Did you do any further research to find out why it's 25 on one side and 30 on the other?
I never could find out why, but it's been that way since I think it was 58 or 52.
So it was
somewhere in there.
dedicated that way?
It was dedicated that way
Okay.
back in the 50s.
It wasn't because of a replat, because of the earthquake?
No.
Okay. All right. Thank you.
Are there any other questions of the applicant? Staff have any questions?
Mr. Chair, I would just make a comment that depending on how the board decides this, condition 1 would have to be changed a little bit, because I referenced the plot plan that was submitted at 1 inch equals 20 feet, dated 6/24/12. Well, we'd need an amended plot plan with no, an amended plot plan, because if it's 24 feet, the plot plan, if it is to be recorded, would have to reflect whatever variance the actual variance is.
Thank you, Ms. O'Brien. And do you understand that if we were to approve the variance, there may be a condition 1 being modified to show a 20 by 24 per your testimony, and then the need to provide an updated plot plan? Thank you. Thank you, Ms. O'Brien. With that, we will hold a public hearing on this. Is there anyone from the public wishing to testify? Anyone at all? Seeing and hearing no one, the public hearing is closed. Does staff have any rebuttal?
No, I don't.
Thank you,
Mr. Chair.
Thank you, Ms. O'Brien. Applicant has 3 minutes for rebuttal. However, I don't think there's a whole lot to rebut, but I don't want to stop you from it. They've indicated they do not have any rebuttal. With that, the matter rests with the board. Again, could I have a positive motion from a board member, please? Mr. Vig.
Mr. Chairman, in case number 2012-098, I move that we grant a variance from AMC 21.040.30G in the R1A district to allow a proposed garage addition to encroach 4.8 feet into the required 20-foot front yard setback, subject to conditions or department recommendations 1 and 2 on page 9 of the staff packet, with the amendment of the garage size being submittal of a plot plan showing a 20 by 24 foot structure. Thank you.
Thank you, Mr. Vig. Mr. Dunham, you indicated seconding that motion?
That's correct.
Thank you, Mr. Dunham. Mr. Vig, would you speak to your motion, please?
Yes, thank you, Mr. Chairman. I struggled with this one initially, but I believe that the timing of the construction and platting and implementation of zoning in this area is somewhat of a physical circumstance in that prior to the zoning existing, there were no setback requirements, and the house was constructed in the position it's in. And so I believe that that's the hand that the applicant's been dealt, and it doesn't appear that there are other options for construction of a garage of a standard size on the lot. And so for those reasons, I believe that there are some physical circumstances that come into play here, and that the strict application of these physical circumstances, as noted in standard number 2, would create, in my opinion, a hardship on the property owner in that other properties in this zoning district enjoy two-car garages. And so I believe that that standard is met, and that standard number 3, again, is something that's occurred through no fault of the current applicant. It was something that occurred back in the 50s, apparently, when the house was constructed and zoning was imposed. So I believe that standards 1, 2, and 3 are met. I agree with staff's findings on standard number 4, 5, and 6. I originally was struggling with standard number 7 myself, believing it to be a 3-car garage, and the applicant has satisfied my concern that they've rethought that and have changed the dimensions, and so I believe that I can now agree that that is a minimum variance that would make a reasonable use of the land in having this garage. So I intend to support the motion.
Thank you, Mr. Vig. Mr. Dunham?
Mr. Chairman, I intend to support the variance request for many of the same reasons that Mr. Vig mentioned. But I'd also like to say that I find the dedication of the right-of-way an interesting issue here, because and I believe what the petitioner's representative said is true, if the dedication had been 25 on each side, we wouldn't even be talking about a variance tonight. And I think there's a substantial number of similarly situated homes as proposed by the petitioner that this would actually be in character with the community and visually would not stand out as an odd-looking structure in the community. So I intend to support the request.
Thank you, Mr. Dunham. Are there other comments from any board members? Ms. Williams.
Thank you. I also intend to support the motion and would only add to Mr. Vig and Mr. Dunham's comments that the only other possible location for a garage would be in the back, which would require construction of basically an alleyway and a driveway and removal of a lot of trees and looks to be extremely disruptive to the neighbor to the east and would actually take away from the character of the neighborhood. So that also weighed into me on Standard 7, that the option they chose was the minimum possible to be able to construct a garage.
Thank you, Ms. Williams. Are there any other comments from any of the board members? If not, please vote. That motion passes by a vote of 8-0. Again, for the record, every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. That brings us to case 2012-099. The applicant is Roger Nelson. Is the applicant here? They've indicated they're here. Could staff provide us with the sufficiency of notice, please?
Thank you, Mr. Chair. By July 18th, 2012, 42 public hearing notices were mailed to the surrounding property owners within 1,500 feet. The property was posted with public hearing signs, and a public hearing notice was published. By the time the report was written, 3 comments were received from surrounding property owners supporting the variance request. The Glen Alps Community Council did not comment on this case. This is a variance from AMC 2140-070G, minimum yard requirements, and 2145-030A, accessory buildings, to allow an existing 21 by 25-foot accessory structure to encroach 5 feet at its greatest point of encroachment into the 10-foot side yard setback. This is a non-conforming lot of record in the R8 district that is required to conform to the yard requirements of the R5A district. So the petition site is a 1.24-acre lot in the Glen Alps Community Council. There is an existing 2,100 square foot single-family home on the east side of the lot. There are 2 saunas and 1 shed also located on the site. The shed contains an intermittent sand filter system for the septic system, and that is the structure that is encroaching into the setback. The site slopes nearly 25% to the northwest, dropping 60 feet in elevation, and there is a 40-foot scenic preservation easement along the southern property boundary. The site is surrounded by large lot single-family residential uses to the east and south. To the west, the property has not been subdivided. And to the north, abutting the property line where the variance is requested, the property is owned by Alaska Communication Systems, and they currently have a communications tower located there. ACS has written a letter supporting this variance. This site was platted in 1972 prior to zoning, and the site was zoned R8 in 1974. The lot area is less than the area required in the R8 zoning district, and according to a non-conforming determination that was completed in 2010, the subject property is a legal non-conforming lot of record, and the yard and lot coverage requirements of the R5A district would apply. The determination also specified that the north side of the property would be considered a side yard, so therefore a 10-foot side yard requirement would apply to the north property boundary. In speaking to the findings, staff found that standard number 1 is met. The site has exceptional physical circumstances given the 40-foot scenic preservation easement and the nearly 25% slope that covers the majority of the site. Staff finds that standard number 2 is substantially met. The structure is an existing structure, and according to the applicant, a waterproof snow load rated covering is required for proper function of the filter. Requiring the petitioner to move the existing shed and filter system would create an undue economic hardship. Staff found that standard number 3 is met. The shed and sand filter was constructed by a previous landowner and is not the result of the actions of the applicant. Staff found that standard number 4 is met. This variance will not impact the use of the adjacent properties, and the property owner to the north supports the variance request. Staff found that standard number 5 is met. This request is dimensional and will not allow a use that is prohibitive in the R8 district. Given the trapper cabin style of the shed with a vegetated roof, the structure is compatible with the character of the zoning district. Staff found that standard number 6 was met. No area-wide impacts have been identified or health or safety issues. And staff also found that standard number 7 was met, and only a small corner of the shed is actually encroaching into the setback. And given that it is an existing structure, this is the minimum variance necessary. So the department found that all 7 standards were substantially met and therefore recommends approval of both the variance from AMC 2140-070G, minimum yard requirements, and AMC 2145-030A, accessory buildings, subject to condition number 1 on page 6 of the staff report.
Thank you, Ms. Iverson. Are there any questions of staff? Mr. Patrick, you had a comment?
Yeah, I apologize. I failed to disclose that I had worked on this particular easement issue because the company that I work for owns that piece of property to the north. I just forgot about it.
Okay. Do you have any? Are you requesting to? Do you feel you have a conflict of interest in hearing this case?
No, I'm not.
Thank you. Does anyone have any questions of Mr. Patrick? Mr. Dunham, did you have a statement you were going to make? No. Okay. Is there any opposition to Mr. Patrick hearing? Could we have a motion to participate? Mr. Dunham.
Mr. Chairman, I move that we direct Mr. Patrick to participate in this matter.
Thank you, Mr. Dunham. Mr. Vig, you seconded that?
A second.
Thank you. Is there any opposition? If not, Mr. Patrick is directed to participate. Ms. Williams, do you have a question of staff?
I did, thank you. Through the chair, I apologize if I missed this in the staff packet, but what do you know what year the shed was constructed? It appears from the pictures to have been located there for some time, but I didn't know if there was a date attached to that construction.
Through the chair, Ms. Williams, on page 31 is the land use determination, where they sort of try to figure out the chronology of when everything happened. And it wasn't exactly clear to me exactly when it was constructed, so they sort of speak to on a specific date they reviewed an aerial photo and found a certain number of structures. And when I read through this, it wasn't clear to me that they knew exactly when the shed was constructed, but they did determine that it was that it was constructed in the time frame that would require them to get to comply with the zoning requirements of the R5A district. Perhaps the applicant can speak to when that shed was constructed.
Thank you.
Are there any other questions of staff? If not, could the applicant come forward, please? Could you
Good evening, ladies and gentlemen. I'm
state and spell your name for the record?
Roger Nelson, RODGERNELSON.
Thank you, Mr. Nelson, and you have 10 minutes for your presentation.
Okay, well, I happen to be in the enviable position of having the zoning department or the planning department analysis support all 7, so I'm not going to take up any more of your valuable time than I need to. I'll entertain questions to answer your question right offhand, Ms. Williams. Talking to the previous owner of the house, we've only been there about 2 years. The septic was put in about 1992, and then he doesn't remember how soon after that he built it. It must have been right away, though, because, again, that has to be covered. The sand filter has to be covered from the weather. So, and really talking to him, he had no malicious intent or anything. The sand filter apparently was allowed to be up to 2 feet from the property line at the time that they put it in, and he didn't decide to build this structure over it until after he put it in and saw that, oh yeah, it's right in front of my front window. I don't want a big white box. If it had been under 30 inches above the ground, that would have not set off the encroachment, I guess. Anything under 30 inches doesn't count. But because he decided after they had already put in the sand filter to build the structure instead, that's where the issue happened. So I'd be happy to answer any other questions.
Thank you, Mr. Nelson. Are there any other questions of the applicant by the board? Seeing none, thank you. Does staff have any questions of the applicant?
No, thank you.
Thank you. If not, if you'll have a seat, we will open the case up for public testimony. Is there anyone from the public wishing to testify? Please come forward. If you would.
My name is Richard Pierce. My family has property on the east side.
Did you say Pierce? Could you spell your last name?
P-I-E-R-C-E.
I'm sorry?
P-I-E-R-C-E.
Thank you, Mr. Pierce.
My family's been on the property on the east side of Mr. Nelson's lot. I've been there since 1986. I was there during the construction of the septic system in question and the subsequent construction of the shed over it by the previous owner. Basically, for my house, aesthetically, there's no issues involved. I cannot even, when I look out my window, I cannot even see because of a fairly extreme drop in elevation. I cannot even see the shed from my house. So there's never been any problems there. So I just wanted to say that the only thing I can actually see is the communications towers there that ACS has on the lot. And they've always been very good in allowing right-of-ways, driveways, and things like that. So.
Thank you, Mr. Pierce. Are there any questions from the board? Thank you. Oh, I'm sorry, Mr. Pierce. We did have a question that came in. Mr. Vig.
Thank you, Mr. Pierce. I'm sorry, maybe I missed it, but to sum it up, you have no objections to granting the variance?
No, of course not.
Just wanted to make sure I understood that correctly. Thanks.
Thank you. Is there anyone else from the public wishing to testify? Anyone at all? Seeing and hearing no one, the public hearing is closed. Does staff have any rebuttal?
Thank you. I just want to, I had a chance to look through that non-conforming determination and the dates, and I think what the applicant said fits in there. It says that in 1993 there was an aerial photo that showed the house with an addition, and then the next date we have is the survey done in 2010. So the shed was built somewhere, according to municipal knowledge, between 1983 and 2010. Thank you.
Thank you, Mrs. Iverson.
Keep a tight leash on it.
Are there any other? Thank you. Does the applicant have any rebuttal? He's indicated he does not. With that, the matter rests with the board. Could I have a positive motion from a board member, please? Ms. Williams.
Yes, thank you. In case number 2012-099, I move we grant a variance from AMC 21.40.070G and AMC 21.45.030A to allow an existing 21 by 20-foot accessory structure to encroach 5 feet at the greatest point of encroachment into the 10-foot side yard setback of a non-conforming lot of record in the R8 district that conforms to the yard requirements in the R5A district in accordance with AMC 21.55.020, non-conforming lots of record subject to condition 1 on page 6 of the staff packet.
Thank you, Ms. Williams. Mr. Dunham?
I second.
Thank you, Mr. Dunham. Ms. Williams, would you speak to your motion?
Yes, thank you. I agree with staff that all 7 standards are met and concur with their findings, and so do intend to support this motion. I would only add on standard 4 that I believe that removing the structure would cause more disruption to the neighboring properties. The structure blends into the environment, and removing it would expose all the equipment on the inside. And also, the most affected property owners both have expressed support for the variance. And also for Standard 7, it appears that the structure has been in place for around 20 years, and no complaints or issues have been raised. So granting the variance rather than requiring the structure to be teared down is de minimis to me. So for all those reasons, I intend to support the motion. Thank you.
Thank you, Ms. Williams. Mr. Dunham.
Thank you, Mr. Chairman. I also intend to support the variance request and concur with staff's findings and Ms. Williams' findings as well.
Thank you, Mr. Dunham. Are there other comments from any of the board members? If not, please vote. That motion passes by a vote of 8-0. Again, for the record, every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. How is the board doing? Can we hear one more case and then maybe take a break after that? All right, we'll charge on. 2012-100, the petitioner is Cook Inlet Housing Authority. Is the petitioner's representative here this evening? The petitioners indicated they are here. Could I have the sufficiency of notice, please, from staff?
On July 18th of this year, a total of 87 public hearing notices were mailed. As of this writing, no comments have been received from the Mountain View Community Council or the public.
Thank you, Mr. McLaughlin. Could you proceed with your presentation?
Thank you. This is a request for a variance from the portion of, from the section of municipal code that requires 12 dwelling units per acre on the B3 district for residential development. 12 units per acre equates to 8.6 dwelling units on this site. If the variance is approved, then there would be 9.6 units per acre, which equates to 7 dwellings. The Cook Inlet Housing Authority is proposing to build 7 2- and 3-bedroom townhome units as part of an affordable housing development in Mountain View. The site is currently vacant. The lot contains 31,452 square feet, almost 3/4 of an acre. However, very steep topography affects approximately 58% of the lot and affects this lot a little bit more uniquely than other lots in the area. The department finds that all of the standards, all 7 standards of approval appear to be met, and therefore recommends approval subject to conditions 1 and 2 on page 5. There is a site plan drawing on page 6 and a topography map verifying the topography issues on page 7, and then zoning map on 8, and 9 is an aerial photo. Land use map is on page 10. There is a perspective rendering of the development on pages 30 and 31, which show from ground level what these townhomes would look like. That is all that staff has for presentation. Thank you.
Thank you, Mr. McLaughlin. Are there any questions of staff by the board? Seeing none, could the applicant come forward, please? And could you state and spell your name for the record?
Yes, Tyler Robinson, R-O-B-I-N-S-O-N. I'm with Cook Inlet Housing Authority.
Thank you, Mr. Robinson. You have 10 minutes for your presentation.
Thank you, members of the board and staff. We ask that you agree with staff's finding and our desire to grant us a variance. In this case, allowing us to build 7 new units of housing on Mountain View Drive. It's not often that we come forward to ask permission to build less on a particular lot. In this case, we've actually run a couple of different development scenarios, one of which we had 12 units on the site. Unfortunately, in the process of doing so, we were considerably into the hill to the south of the site. Obviously, that drives up development costs. The other problem we had was an issue with the traffic department and a maneuverability issue as we tried to sort of essentially build 2 rows, not full rows, but 2 deep buildings on that particular site. We feel that 7 units of townhouse-style development is appropriate. We recognize it's B3 and also looked at the site for commercial development. We do and recently completed a mixed-use building immediately to the west that has retail on the ground floor and housing above. That, however, has a better location for retail, given that there's Park Street there and access for the retail. This is on a curve, and also, no matter what you did there, you would be impacted by the buildable area on that lot. Just as a simple point of math, we ran what 7 units would do on the buildable area. If you look at the 11,000 some square foot of buildable area, we'd be building at 23 DUA. So with that, we feel like, frankly, we're not negatively impacting. In fact, we'd like to think we're positively impacting the neighborhood and the community, and urge your concurrence with this finding. Thanks.
Thank you, Mr. Robinson. Are there any questions of the applicant by the board? Yes, Ms. Wallad.
Through the chair, Mr. Robinson, I am familiar with the steep grade that you're dealing with here. Can you explain the 20-foot separation between the 4-unit and the 3-unit? Is that parking, amenity space?
I believe it has to do with, sort of how we were trying to adjust a little bit of the angle of the building, if I'm not mistaken. But offhand, I don't know. We're trying to create a little bit of a space there, a common space, a gathering space. There's great southern exposure, and I believe that's also one of the rationale for pulling those units apart rather than having a closer row.
Okay, thank you.
I'm looking at on your application. There's a. Let's see if I can get it on the page numbering. It appears you have a sewer line that's in that open space area.
You're right, Mr. Chair. I neglected to mention that. There's a storm sewer easement that runs through that section.
Yeah, it looks like it's a sanitary sewer for the...
Yeah, you're right. I'm sorry.
You're right.
I see that now.
Thank you. Are there any... Ms. Watt, did you have any other questions?
No, that's everything. Thank you.
Are there any other questions of the applicant and the board? If not, does staff have any questions?
No, Mr. Chair.
Thank you. Mr. Robinson, if you'll have a seat in case we need you to come back for rebuttal. Is there anyone from the public wishing to testify? Anyone at all? Seeing and hearing no one, the public hearing is closed. Staff have any rebuttal?
No, Mr. Chair.
Does the applicant have any rebuttal? Mr. Robinson? He has indicated he does not. With that, the matter rests with the board. Could I please have a positive motion with respect to this case? Ms. Denny?
Yes. In the case of 2012-100 Cook Inlet Authority, I request that we grant a variance from AMC 21.40.180B.3.A to allow less than 12 dwelling units per acre for multifamily residential use in B3 district, subject to the conditions on page 5.
Thank you, Ms. Denny. Mr. Dunham?
Yeah, I second.
Second. Thank you. Ms. Denny, would you speak to your motion, please?
I agree with staff's findings that all 7 standards have been substantially met, and I commend the Cook Inlet Housing Authority for actually trying to put less density units on a piece of property than more, which is what we've usually seen in the past, and I intend to support the motion.
Thank you, Ms. Denny. Mr. Dunham?
I also intend to support the motion, and I concur that all 7 standards have been met.
Thank you, Mr. Dunham. Are there any other comments for any of the board members? Any other comments at all? Seeing none, please vote. That motion passes by a vote of 8-0. For the record, every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. That case was quicker than I'd anticipated. Should we continue on? All right. Our next case this evening, case 2012-097. The petitioner is the applicant, Fred Meyer Stores, Inc., representation, Barkhausen Consulting Engineers. They're indicated they're here this evening. Ms. Ferguson, this is your case, I believe. Can you provide us with the sufficiency of notice?
There were 82 public hearing notices mailed on June 29th. We received I take that back. We did get one response back after the report was written. The principal use on the site is what?
Thank you, Ms. Ferguson.
The principal use on the site is a retail store and the gas station. The proposed renovation and expansion will add 4,179 square feet to the store gross floor area for a total of 168,207 square feet, which requires 561 parking spaces under current code. However, they have currently 455 parking spaces, which is a 16.82% deficiency. The proposed renovation and expansion necessitates an increase in the number of parking spaces. As a result, a parking variance is needed as the applicant is proposing to increase the degree of noncompliance per code for the parking spaces. No existing parking spaces will be lost. The issue is that no new parking spaces will be added with the building expansion. A parking study was done by Kittleson and Associates in February of this year. It confirmed that the parking supply is sufficient to accommodate the parking demand. A variance for the number of parking spaces shall be granted on the basis of the demonstrated need for the parking. The intent of this standard is that the applicant can demonstrate the amount of parking required by current code is in excess of what is actually required to serve the proposed use. This standard is substantially met. The applicant has submitted a parking study which appears to indicate that the parking provided is in excess of what is needed. The parking study indicated that at peak, our average parking demand was at 282 parking spaces for a Friday and 346 parking spaces for a Saturday, so it appears that there is sufficient parking on the site. Number 2, spillover parking onto other properties will be avoided. The intent of this standard, is that if a parking study supporting Standard 1 turns out to be incorrect and the code required amount of on-site parking is needed, the applicant can indicate an area on-site that can be paved, striped, and dedicated to permanent parking. While the standard is not technically met, as there is no other parking options on site, unlike other land uses such as multi-residential or office, if there is not enough parking, customers can elect to leave and shop elsewhere. There are no spillover parking on nearby properties as the site is surrounded by major roads on 3 sides. On the 4th side, there is a retail strip mall and an office building to the east of the site. But to use those parking spaces, store patrons would have to walk a long distance, and this would not likely be a feasible choice. Therefore, this standard is substantially met. The Traffic Division has reviewed the parking study and does not object to the variance request. The department recommends approval as the results of the parking studies appear conclusive. However, if after the public hearing the board establishes finding that the standards are substantially met, the department recommends approval subject to 2 conditions as shown on page 8 of the staff packet.
Thank you, Ms. Ferguson. Are there any questions of staff by the board? Seeing none, could the applicant come forward, please? Can you state and spell your name for the record?
Yes, my name is Robert McNeil. I'm the senior planner with Barghausen Consulting Engineers. My name is spelled M-C-N-E-I-L-L.
Thank you, Mr. McNeil. You have 10 minutes for your presentation.
Briefly, the staff has given you the numbers associated with our proposal. Fred Meyer is consistently looking for ways to expand and renovate their stores to better serve the community. In this particular case, we were building off of a site plan that was essentially formed in 2010 when the gas station was constructed. At that time, we worked with the Traffic Department in Muni and the State Department of Transportation to devise, internal circulation and access improvements that essentially fixed the parking allocation at this time. The goal for the expansion and renovation of the store was not to intrude any further onto the parking situation than possible. We were able to succeed with that using a design that's being produced right now by Group McKenzie. Specifically to answer any questions you might have on the parking study and its methodology, we have Mr. Gary Katzian of Kittleson Associates, and we also have Mr. Tom Gibbons of Fred Meyer here to address any questions about the expansion. Thank you.
Thank you, Mr. McNeil. Are there any questions of the applicant, board? Mr. Vig.
Thank you. Through the chair, Mr. McNeil, followed the logic in the parking demand study and so on, but just for my own information, can you direct me to an exhibit that shows the nature or the location of the intended improvements on the store?
There was a separate application that was made to the municipality for a site plan review. If you look at our sheet DD1, which is the overall site plan, you will see a shaded area right at the corner of the store, it'd be the northwest corner. That is essentially the only area that you will see any expansion of the building footprint right now, and that is approximately 1,500 plus square feet. The majority of the 4,179 square feet of expansion is being accommodated on a mezzanine inside the store. The the improvements to the aesthetics of the facade that have been proposed by Group McKenzie basically accounted for the need for this minimal expansion outside. But we were able to contain it basically within the existing circulation area immediately adjacent to the building and not remove any parking or make any parking adjustments.
Okay, thank you.
Mr. Ron.
Thank you. Thank you, through the chair. Mr. McNeil, I have a question about the timing of the parking study. It was indicated that the study was completed in February. Is that correct?
I believe so, yes.
And has parking been evaluated at any other month during the year?
There was a parking study done, I don't remember the specific month, in conjunction with the gas station, and it was done by the same firm. Essentially the same results. There were some minor differences in the numbers. So we do have two independent studies, or times that, studies that were taken at independent times. We did contact Muni to verify when they would like the study done, and they suggested we should do it after the holidays and after the peak periods, and that thus the timing of this particular study was concluded.
Thank you.
Are there other questions of the applicant by the board? Any at all? Seeing none, thank you, Mr. McNeil. Did staff have any questions of the applicant?
I don't, Mr. Chair.
Thank you, Ms. Ferguson. With that, we will open the hearing up for public testimony. Is there anyone from the public wishing to testify? Anyone at all? Seeing and hearing none, no one, the public hearing is closed. Staff offer any rebuttal? Ms. Ferguson, no rebuttal, I'm assuming? Thank you. Mr. McNeil? I'm assuming no rebuttal? Thank you. With that, the matter rests with the board. Could I have a positive motion from a board member, please? Mr. Ron.
Thank you, Mr. Chair. In case 2012-097, I move that the board grant a variance from AMC 21.45.080B to allow fewer than the required number of parking spaces and to increase the noncompliance of the number of parking spaces associated with the building renovation and expansion in incorporating department recommendations numbers 1 and 2 on page 5 of the staff packet.
Thank you, Mr. Ron. Mr. Vig, you've indicated you'd second that motion?
I do.
Thank you, Mr. Vig. Mr. Ron, could you speak to your motion, please?
Thank you, Mr. Chair. I do intend to support the motion and would like to incorporate staff's findings, their narrative 4 findings, numbers 1 and 2, as written in the staff packet and recorded into the record during staff's presentation. I can concur with those findings. I would, however, like to, for the record, indicate that I feel that the parking numbers indicated based on the February study are not necessarily indicative of a year's worth of, or rather other months' parking utilization for the facility. And looking at page 7 of the staff packet, you'll notice what appears to be a summertime photo, and there seems to be an awful lot of cars in that parking lot. Clearly, this isn't well calculated out, but by inference, it looks like it's a weekday. The property to the south, I believe, is the BP building. There are cars in that parking lot, and so we're not talking peak retail hours. Just thought I'd read that into the record. However, in consideration of that and department's statement that if there aren't parking spots, consumers can go elsewhere, and that's at the retailer's fault, I intend to support the motion. That's all.
Thank you, Mr. Ron. Mr. Vig.
Yes, Mr. Chairman, I concur with staff's findings and Mr. Ron's analysis, and I also intend to support the motion. I have no other comments to add.
Thank you, Mr. Vig. Are there any other comments from any of the board members? I also intend to support the motion and concur with Mr. Ron's comments and concerns and statements with regard to the study and the timing of it. However, I also will be supporting the motion. Are there any other comments? If not, please vote. Yeah, I thought I did. That motion passes by a vote of 8-0. For the record, every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. Okay, with that, I'm going to ask the question again. Does anyone need a break? Or should we hear this last case?
If I could have a break long enough to walk down and get a bottle of water, I would be most grateful.
All right, we'll do that. And I believe Ms. Willard will be recusing herself from this case.
I will. Thank you.
All right, and Ms. Willard, you'll have to leave the chambers, and seeing that this is the last case of the evening, unless you really want to come back for my closing remarks, which are going to be memorable, I don't see a reason for you to stay. The last case this evening is case 2012-101. The applicant, Cook Inlet Housing Authority, Representative Tyler Robinson, is here this evening. Could staff provide us with the sufficiency of notice, please?
On July 17th, 122 public hearing notices were mailed. At the time this report was written, one public comment was received in opposition to the granting of the parking variance. No responses were received from the Eagle River Community Council. The two public hearing notices that were returned to the department are on pages 45 and 46 of your staff packet, and I'd like to read them. The first public comment says, seems like they should comply with parking regulations too, as Coronado does not have wide shoulders for guest resident parking, and Coronado Street already has excessive traffic for a side street. On the back of that, the other person who commented said that they strongly recommend that the facility be pet-friendly and allow animals. That's all.
Thank you, Mr. McLaughlin. Could you proceed with your presentation?
Thank you, Mr. Chair. The site has 1.4 acres in a split zone, B3 and RO. The Cook Inlet Housing Authority would like to build a 4-story, 56-unit affordable, independent senior housing development. The proposed site plan needs a parking variance to be approved. The department finds that both standards 1 and 2 are met. In regards to standard 1, a parking study was conducted by the petitioner that shows the proposed senior affordable housing development will only utilize approximately 37% of the parking spaces that are required by current regulations. The traffic department has stated that they support a parking variance reduction to 76 spaces. Pages 18 and 24 of the traffic study done by the petitioner chart a comparison of what would be the required, the parking requirement under forthcoming changes to our parking ordinance. In regards to standard number 2, staff has written that if assumptions about parking demand are incorrect, then there is sufficient space to accommodate additional parking on site. The garden area can be converted to additional parking spaces. The department recommends approval of the parking variance subject to conditions 1 and 2 on page 3 of the packet. That's all I have.
Thank you, Mr. McLaughlin. Are there any other questions of staff by the board? Any at all? All right, thank you. With that, could we have the applicant come forward and state and spell your name for the record, please?
Tyler Robinson, Robinson, with Cook Inlet Housing Authority.
Thank you, Mr. Robinson. Would you proceed with your presentation?
Thank you. I would like to reserve 2 minutes for rebuttal. Just a point of background, Cook Inlet Housing Authority is a developer, owner, and property manager of housing in Anchorage as well as the Mat-Su Valley and the Kenai. We own about 934 rental units when we complete our development at A and C Street later this fall. We also own out at Peck and Muldoon Road 367 units of senior housing. We call that our Centennial Campus. And that particular campus was the basis for our parking study. 4 of the buildings that were used to study over 2 separate time periods were chosen because they were sort of independently grouped, where you can't really mistake spillover parking. If you're parked there, you're very clearly a visitor or resident of those buildings. But also because those buildings have very similar income mixes to what we're proposing to build in Eagle River. I'll get into the study in just a moment. I will say that this particular proposal in Eagle River falls under a couple of sort of municipal planning documents. One is the Eagle River Central Business District Revitalization Plan, which is an element of the comprehensive plan. And the other is an ordinance passed a couple years back called the Eagle River Downtown Overlay District, which is the community's attempt to foster a downtown in Eagle River. We believe this development will certainly help to do that by bringing people to the area, infill housing. This is a redevelopment of a former trailer park, the larger site. That's what I'm speaking of, the 12-acre site. This is 1.4 acres of that larger site that extends to the south. We have support for the project from the Eagle River Chamber of Commerce, and I believe that, again, that our development will be a benefit to the commercial development and not be a hindrance on the residential developments adjoining the site. Back to that parking study, what we did is we found, and what staff quoted was, we basically used 37% of what would be required if you add all of those 4 sites up. Now, we didn't actually build that amount of parking. If you look at the calculations of what we built on those sites, it's substantially less. In fact, we built about 30% less than what would have been required by code. The reason is over the years we've been successful with variances or reductions in parking in recognition that we're serving a different population that doesn't exhibit the same amount of auto ownership as the general public. One thing in our code, our current code, is there's no distinction with residential development. You're either a residential development and they treat everything equally, whether you're, market rate housing, affordable housing, senior housing. That is something that's been proposed to change in the provisionally adopted code. It's also something that's pretty commonly seen in other communities as a way to encourage efficient use of land, essentially not requiring parking to be built that's not going to be used. We conservatively estimated, and I think we show it on those bar graphs if you look at them on page 23 of your packet. The large bar is the current required parking. The small bar to the right is what we observed, adjusted for any vacancies. We have generally about 2% vacancy, so we added, assuming that each of those vacant units had a car, we added back. And the two bars in the middle, the orange one is what you would see under the proposed Title 21 code for a market rate development. The green bar, the code recognizes further reductions, again, for senior housing and for affordable housing. I will note that, when we talk affordable housing, sometimes we're not talking about 100% of the units being affordable housing. We will mix the units when we can. In other words, have non-income restricted units. We like to encourage a mix of incomes in order to serve a number of different populations, and that is certainly the case here. On page 24, we talk about the sort of the estimate driving 50% of what the code would require, which would be 99 spaces for a 56-unit development. We sort of estimated demand to be about 50%, which was the high mark of those other developments where you saw 37% across the board. Since we submitted this variance, we did go back and we adjusted what we proposed to be our income mix. So I won't go into all the details, but whereas when we presented this to you, we said we would build 12 market rate units, we're actually proposing to build 18. So we also took some of the units that were restricted at 60% of median and further restricted them to 50%. So in other words, we went both directions. What we find is families and households at 50% in a senior development are often seniors living on a fixed income, and that's what you have. And so you have very much a sharing of cars. Those that are able to drive and can drive organize a shopping day, and they go out and shop together. But car ownership is much lower than, again, what you would see typically. Even with that change, we approached traffic and said, hey, even with those 6 changes, if we just assume that each of those 6 have an additional car, so we go from 50 spaces to 56 spaces, we're still proposing a total of 76 spaces at the site. So we're still proposing considerably less than what we see at our properties and what we're honestly estimating for what the demand will be at this particular site. In order to assuage any other concerns, we've shown on a site plan that we could actually provide the full amount of parking spaces. It would be at the detriment of the development, and we simply don't believe that it's necessary. We believe it would take away from some of the other amenities that will be, I think, good for both residents as well as the general community. These include some extra garden spaces, some additional pathways, wider pathways as well. I'm happy to answer any questions that you have about the methodology of the study, how we conducted that, as well as how our operations work. I would simply add that we're not just a developer, we're an owner here in town. We know that we have a lot riding on our developments. We don't want something to go the wrong way because we come back and this is where we live. So with that, I'd be happy to answer any questions that you have.
Thank you, Mr. Robinson. Mr. Dunham.
Yes, Mr. Robinson, this study group that you looked at is senior housing, correct?
Yes, sir.
Is the site for the variance also going to be senior housing?
Yes, what we've proposed of the 56 units, it's 100% senior development. So all 56 units are restricted to 55 and older is essentially how our funding sources work. In actuality, what we see as an average is about at age of 67, 68 years old, and we would expect something similar here. On top of that, there's units that are restricted to maximum incomes that you can make in order to qualify for those units. So, from a general observation standpoint, that also has an effect on automobile ownership.
Okay, thank you.
Are there any other questions of the board? Question by the board. Mr. Vig.
Thank you. Through the chair, Mr. Robinson, would Cook Inlet Housing be willing to entertain an additional condition that after the units are completed and occupied, that there would be a follow-on parking demand study to ascertain whether there is a problem or not, and if so, to construct additional spaces that might be needed?
Through the chair, Mr. Vig, I think that would be fine. I mean, we look at our projects all the time and frankly work hand in hand with the city to try to figure out what's the right amount of parking to encourage efficient land use in this town. We certainly don't want to create a parking problem. I think as long as that condition is worded such that if there is additional demand, we wouldn't have to go necessarily all the way back to 99, but we could look at what that demand is. I think that we would gladly commit to doing that.
Okay, thank you.
Are there any other questions of the applicant by the board? Does staff have any questions?
No, Mr. Chair.
Thank you. Thank you, Mr. Robinson. With that, we'll open the hearing up for public testimony. Is there anyone from the public wishing to testify? Please come forward. Will you state and spell your name for the record?
Glenn Gage, G-A-G-E.
Thank you, Mr. Gage. You have 3 minutes for your testimony.
Number one, I believe that the parking requirements are being underestimated, particularly during the winter months. As noted in one of the pages that were returned, that area is an old part of Eagle River, one of the original ones. Coronado does not have any sidewalks, nor does it have any street lights. I see day to day going out there, I see kids walking up down the street, they're having to get into the street, having to dodge moving vehicles. I see women with strollers having to do the same thing. I do not believe their studies. I think they're flawed. Their numbers. I believe that you will see that there will be parking that will take place on Coronado or even up on my street on Lower Sunny. They're talking about so many cars per unit that are there. What about all the people that are visiting? Even if it's not going to be, the parking's not going to be utilized 100% of the time, there will be times when it is going to impact on our community, of which they are not part of. This is if you want to rather than reduce the requirement for parking, which is what the community has said, X number of parking spots per unit and everything, rather than do that, they need to reduce their footprint in the community, have less apartments. Because also, we're right now focusing in on one small portion of the whole development that they are undertaking. The rest of that whole area, which was clear cut, which has impacted my family for the last 3 years, all right, it's still ongoing, and now they're coming up and asking for more variances. So I would strongly request that you not allow this to take place, and to look at not only this one small portion, but what other variances they could ask for in the future for the rest of the development that's going to take place. Thank you.
Are there any other any questions of Mr. Gage by the board? Mr. Dunham.
Mr. Gage, could you show the board or tell us what lot you own?
By this, I live on Upper Sunny Circle, on Lower Sunny Circle, so it is the road that just goes past the Conquistador Drive. So my backyard, I'm not sure whether you see the exact same thing that I have here, but it is approximately just above where the R-O is situated.
Okay. Thank you.
Are there any other questions of Mr. Gage? Ms. Denny.
Yes. You mentioned something about that they're clear-cutting those lots, and what was stated earlier was that was a former trailer court?
Yes, it was. It was a former trailer court, and the first year, which now we're talking approximately, not this summer, but 2 summers prior to that, they came through and, in effect, tore out everything. Spent the following summer with them going and doing all of the work on laying the roads and all the rest of it. Last fall, they did plant some trees, and this year they have been nice enough to go out and hydro seed, which is just starting to take place. But this has not been anything that's happened very quickly, and it is an eyesore, and it is problematic as to what is happening and what is going to happen at any given time for the neighborhood.
Would you prefer that the trailer court was still there or this development?
The trailer court.
Thank you.
Okay.
Are there any other questions of Mr. Gage? I do have a question, Mr. Gage. We have, I guess, one statement and then one question. All that this board is hearing tonight is this variance, and that's all that we're going to act on. We have a traffic study that's been submitted, reviewed by traffic engineering, concurred with. You said that you believe it's flawed. Do you have any information to provide on what you see as flawed? Or
all I can say is that from day one at the start of this whole thing, knowing that there's going to be, no matter what the agreement is on the parking spots, how many spaces you have and everything, there's going to be a great increase in the traffic. And Coronado is my main ingress and in and out to the neighborhood. And they will not put a traffic light down at the end of the street. Now, everyone in the city says it meets all the requirements. But everyone in the neighborhood, when you talk about it, everyone is well aware that there's just no way it cannot negatively impact on our day-to-day driving to and from work, going to a store, whether we have the option like on the other one where you can just go someplace else. Well, we can't because that's where we live. So all of this, if they don't have enough parking space for the amount of people they're going to put in there, reduce the amount of people they're going to put in there. That seems simple enough.
Thank you. Ms. Williams has a question.
Yes, thank you. Are any of your concerns addressed by the additional condition that Mr. Vig proposed, that once the development is constructed, an additional parking demand study be completed, and then if that demand study shows that indeed there aren't enough parking spaces, the developer would be required to add additional spaces?
My bone of contention with things like that, or I already feel that this thing has taken probably 30 years to come to where we are right now with rezoning that took place years ago before people started thinking, what will happen when this is not a residential area and then it's allowed to change and change. They go in there and they build it one certain way, and now all of a sudden it's going to take the neighborhood to complain about it and to be the bad guy. Well, you're going to have to do without your garden area so you can have more parking spots. So now what you're doing is you're making, as was brought up, if that happens, you are taking away from those people that are living in that area. I don't think it should be left to the future for that. Come up with the way it should be right now, build it that way so that everybody knows how it's going to be, and we're not going to have to worry about changes or someone having to say, well, the people up the hill didn't like the way it was, so you're going to do without your garden area.
Thank you.
Are there any other questions of Mr. Gage? Thank you, Mr. Gage.
Thank you very much.
Is there anyone else from the public wishing to testify? Anyone at all? Seeing no one, the public hearing is closed. Does staff have any rebuttal?
It might be worth noting that the zoning allows quite a bit of development. The B3 district, allows commercial development, which generally produces more traffic, average daily trips than residential development. And the B3, if residential is built there, requires minimum of 12 dwelling units per acre. And with an RO district, you're allowed to have a residential planned unit development, which can be up to 120 dwelling units per acre. So the number of units proposed with this development, it just seems that in terms of what the zoning, the maximum number of dwelling units that could be built on the site, this would be should be considered in relation to what potentially could be built. Thank you.
Thank you, Mr. McLaughlin. Mr. Robinson, you have 3 minutes of rebuttal.
Thank you. Just a couple of points to make. When we conduct our parking study, there's no way to distinguish whether those are residents or visitors. We generally have a community director staff at every one of our buildings. So that's included in the numbers of the parking study. So the comment or the concern that I heard that, are we planning for not only the residents there but the visitors, that's included in sort of that calculation and that plan, and we believe even with that we have in excess of 20 some odd parking spaces. I think, without going into the entire history of the larger development, there was a significant amount of remediation that went on, but this site was always intended to be a senior housing development, and like I've said before, we really approach the municipality when we do these developments to see if there's recognition that from a land use standpoint we're dealing with long-term permanent restrictions of the land, and therefore we don't generate the revenue that you generate when you do a market rate development, and that is why other communities recognize that in addition to that the overall demand is less when you deal with affordable housing. We think that's an incredible need. We have a shortage of housing in this community, period. The downturn has caused an even bigger sort of gap that we're losing track of. But in addition to that, we need affordable housing. Our senior housing is at 2% vacancy. It's full. We believe that there's great market demand in Eagle River. We believe that the opportunity is there, and unlike we heard, we believe we are a member of the community. We're a property owner there, and we intend to be a long-term partner. So with that, thank you, and again, I encourage you to take staff's recommendation.
Thank you, Mr. Robinson. Mr. Vig, you indicated you had a question?
I do have a couple. First off, do you have a standard practice for snow removal on your properties, and well, specifically this one? Would it be a plow and haul off operation, or do you store it on site, or what's your operation?
I mean, typically we enter in any more, given the cost to develop in the community and the cost per foot of land, that we're going to be removing snow on the site. It's sort of a case-by-case basis as to how much we know we're going to be hauling is the short answer. The more practical answer is, what type of temporary storage can you get on the site? We'll store for until the completion of a snow event, but then we know we're going to haul. It's just part of the cost of operations. It's factored into our pro formas.
Okay, thank you. And
and just, I'm sorry, if I may, a condition of the plat that this was a part of, I believe, requires snow removal. It indicates that snow will be hauled, so the platting board has weighed in on the entire site that it's a haul.
Okay. And this particular development is a 1.4 acre site or area of a larger tract. Is that correct? Well,
I think, the overall redevelopment site is a little over 12 acres. So that was the former trailer park and other lots. This is a site that is working with the traffic department, will be accessed from Coronado, and that was approved to provide driveway access on the site from Coronado. The advantage of having built out the remainder of the site is there's a network of sidewalks that were built privately in the rest of the site, and so while we do recognize that automobiles will use what is classified as a collector road in Eagle River, the pedestrians choosing to go down to via Business Boulevard or the shopping there in the Jitters Mall will utilize the sidewalk. In fact, I was out there today, and admittedly we'd like to see development out there. It's vacant, but there were 3 people walking their dogs around the sidewalk of our site, given that that's infrastructure that's been put in that is somewhat lacking in the rest of the neighborhood.
Well, I guess that leads to my bigger question is, do you have a master plan for development of the 12 acres that contemplates what you're doing now and what might be coming in the future on those other areas?
Yeah, and through the chair, I mean, just to clarify, I mean, we are talking about just the variance for this particular site, but to answer your question, the overall, the remainder of the development is approved through a site plan that was approved as part of the platting board. It's been revised recently by the municipality to actually reduce the number of units on the Balances site from 168 to 133. So I think, you know, we purchased the development. We were initially a part owner of the site and purchased it from a number of other partners, and have reevaluated, you know, what the land can hold, what the appropriate land use is. And we've proposed a reduction in the balance of the units on that site, and are amending our site plan accordingly.
Okay, well, the reason I bring it up is that if it turned out that the parking wasn't adequate and there wasn't any option other than to use or convert the garden area to parking, it seems like a better solution might have been to perhaps build to the current requirement, and then if it turns out to be excess, to make use of it in the subsequent phases of the development. But that was the reason for asking about the master plan.
I would just say that whether we were building, 56 units or 40 units, we would face the same dilemma, and that is that the code doesn't recognize that these uses require less parking. And I would make the argument to staff, to you, if it required it, that, rather than put in expensive infrastructure, that we take note of what has been practice and what has been observation in the community and others like ours, and that we sort of go that route, knowing that we can always fall back on something if it's actually necessary.
Okay, thank you.
Thank you, Mr. Vig. Are there any other questions of the applicant? Mr. McLaughlin indicated you had a comment or a question.
Thank you, Mr. Chair. Yeah, just a quick comment. On page 24 of the packet with the Coronado Senior Development, it shows a chart of current code, proposed Title 21 for market rate, proposed Title 21 for affordable senior, and the number of parking spaces provided here, if this development is similar to the one that's being constructed. The number of parking spaces proposed by the applicant for this development in Eagle River is more than what's required for market rate and much more than what's required for affordable. And that's not including the senior housing component. So the traffic engineer, traffic planning has accepted this parking study. Secondarily, a condition that would require a sort of a reciprocal, I don't know the right terminology, but for the applicant to return to the zoning board of examiners and appeals. I haven't personally seen that in my 6 years working in the planning office, and I don't know if there's been a condition on a parking variance or any type of variance to have to return before the board. I was studying municipal code, the section on variances and the standard for which they're approved, to see if a condition of approval requiring the applicant to come back after some number of years and make a presentation. It doesn't appear that such a condition would conflict with the code. I'm just trying to figure out how it would fit into it practically and practicality. So if the variance were granted with a condition that the petitioner have to return and make a presentation to the Zoning Board of Examiners and Appeals, what would likely happen is staff would have to sign off on that condition. No building permit can be pulled to build this development until all these conditions of approval are met and then it's recorded against the deed for the property. So essentially, staff would have to just make a guess that they were going to go and do this and approve it so that they could build the development, because you can't have it both ways. So they build the development, and then there would be no way to obligate them to return and make a presentation. It's tricky. I don't know how it would work. I don't think that such a condition has ever been placed on development, and if such a condition were to be placed, I'm not sure if it would achieve its intended result or if it could be enforced. Maybe we'll all be gone from we won't be around to make sure that this is enforced, but it'll be one of those catches, maybe a black mark on the property in the future, because this is for 100 years or something. It'll always be on the property. I don't know if that'll cause them problems in the future. It'll certainly cause a sort of a discussion after the fact somewhere down the line, and I don't know if we'll be here to address it. Thank you.
Thank you, Mr. McLaughlin. Mr. Vig?
Mr. McLaughlin, are you referring to the third condition I was asking the applicant about? Yeah, I maybe could clarify. It wasn't my intention to ask the applicant to return to the zoning board, but to prior to closing out of the variance, that they would need to demonstrate that the parking study was adequate to planning staff or to traffic or whoever it is that signs off on it, but it would not require another visit to the zoning board. That was my intent.
Thank you. Mr. Ron?
Thank you. Through the chair, Mr. McLaughlin, a tangent perhaps from your last description. What I see us being asked to evaluate is data based on use. And my concern is the use that we're asked to evaluate the data on, based on existing department recommendations, would not carry forward against the deed in case of property transfer or change in use. Then our evaluation of the data would then not be applicable. So I'm struggling with how, if any, there might be a way to, like you said, record against the deed use of the property. I understand that would be restricting to the petitioner, but the line of thinking I'm working towards could use some support from others, perhaps.
Through the chair, Mr. Ron, that's a good question. Thinking out loud, so I sat in a Title 21 Assembly Committee meeting today, and the community supports reducing our parking requirement in code. That's supported by developers, it's supported by community groups, it's supported by housing advocates. So if that, the parking ordinance is in fact passed and becomes, it's provisionally adopted, say it becomes effectuated, then this development wouldn't need, next year it wouldn't need a parking variance whatsoever. It would have, it would be maybe proposing 50 parking spaces. But it's, it's indeterminate when this will actually pass, if at all, I guess. So there's that. Also, the parking variance, I believe, could be granted with the condition that it only apply to an affordable housing or a senior housing development. And I've seen that before, so that, actually there's another development in Eagle River. 20 years ago, the Zoning Board of Examiners and Appeals approved a parking variance to reduce the number of parking spaces. It was built, and then when that, if that property were to ever be converted from affordable housing to become market rate, then the variance would be null and void. That one didn't work out too well because the applicant didn't follow through. This was so many years ago, maybe in the 80s or something. And so it was not recorded against the deed for the property, and it was quickly sold, so the owner has been using it for market rate all along. So it was one of those, caught it now, and now the owner of the property for 30 years is trying to figure out how to deal with it. He'll be coming to you in the future with a possible parking variance. Because, anyway, the cleanest way is to approve it as staff has recommended on page 3. However, it seems like a phrase could be added that the parking variance for affordable housing or senior housing. The trick, though, is that the applicant has talked about there's going to sort of mix. It's not going to be. It'll be purely senior housing, but it'll be a mix of market rate and income restricted units. That's all I have. Thank you.
Thank you. Are there any other questions of staff by the board? Thank you. Thank you, Mr. Robinson. With that, the matter rests with the board. Could I have a positive motion from a board member, please? With the understanding that we need to have a motion and hear it in order to end the case. Mr. Vig.
Mr. Chairman, in case 2012-101, I move we grant a variance from AMC 21.45.080B.2 to allow 76 parking spaces, which is a 23 space reduction, subject to department recommendations 1 and 2 on page 3 of the staff packet. Thank you.
Thank you, Mr. Vig. Mr. Dunham, you indicated you would second that motion. Thank you, Mr. Dunham. Mr. Vig, could you speak to your motion, please?
Yes, thank you. I do give a fair amount of weight to the applicant's studies of prior developments, and I do believe that they're a good operator of their developments, and I believe they're being forthright here and willing to live to a commitment to provide additional parking if it doesn't work out. But so I'm willing to concede that standard number 1 is met. They've demonstrated the amount of parking is in excess of what's actually required. And in fact, and Mr. McLaughlin pointed this out on page 24, that and again, this is not an adopted Title 21 rate yet, but that they're actually providing more than what would be required under the proposed Title 21 market demand. So that made me a little more comfortable with the idea, and that spillover parking can be accommodated on site. The applicant did mention to convert some garden area to additional parking spaces, and I think he answered my question on development of the remainder of the parcel. And so I think there are some concerns here, but I think the applicant's done a pretty good job of addressing my concerns, and so I intend to support the motion. I believe both standards are met.
Thank you, Mr. Vig. Mr. Dunham.
Mr. Chairman, I haven't made a decision yet on this one. I think that the applicant's arguments are sound, and I think that the parking demand comparisons are sound. And as long as we're comparing apples with apples, I think that's good. my concern is if we grant a variance for a reduced number of parking spaces, and in the future, the character of this property changes, say that Cook Inlet Housing no longer has it or transfers it to another entity, and they decide that they're going to use it for something else, like just regular old apartments for generating income, then the character of parking and the use of parking changes. So I'd like to hear a little more from the rest of the board about a way to condition this so that it's not going to run away from us in an uncontrolled manner.
Thank you, Mr. Dunham. Are there other comments from any of the board members? Well, I'll weigh in, Mr. Dunham. I intend to support the motion, and with respect to your question, looking at the traffic study that has been done, and again, referring to page 24 of the packet, we've heard we get a number of variance requests for parking studies that come in with variance requests for parking spaces with parking studies that have been done. I think it's clear in my mind that even if the use was to change per market rate, there'd be sufficient parking to handle that per the study that was submitted. And I also give significant weight in this case to traffic weighing in with no objection. So I feel that even if the use were to change, there's adequate parking with what's proposed. The factors that are used on establishing parking, the number of parking spaces are not exact in that it's a number of spaces based on square footage and dwelling unit. But in my mind, there's enough information provided before us for me to support the motion. Ms. Williams.
Thank you. While I'm very sympathetic to the public's concerns, I also do intend to support the motion as well. In addition to the comments that have been made, I also put weight in the applicant's history with this sort of development and the type of parking demand that is required, and the fact that those studies have included residential as well as visitor parking, and it still shows a great reduction in the amount of parking required compared to what is required by current code. And also, as has been stated by other board members, if there is greater parking need than the 76 spaces, it can be accommodated on site by converting the garden area to parking spaces. So for those reasons, I do intend to support the motion.
Mr. Ron.
Thank you, Mr. Chair. Following up on Mr. Dunham's comments, Mr. Dunham, I raised the line of questioning regarding change in use, and it's still a concern for me as well. Although I am slightly assuaged by the graph shown on page 24, in that the variance request is slightly above proposed Title 21 market rate, and if the use were to change for this property, it would be most likely to that market rate. I would feel more confident if we could come to terms with some type of additional recommendation for approval that perhaps hybridizes Mr. Vig's initial line of questioning regarding the reassessment of parking need validated by on-site evaluation with a change in use.
And I'm just, I guess I'm not aware of just a statement, aware of how we could
do that.
we could add that condition. Yeah.
Okay.
Not saying it can't be done, but I'm just not aware of how we do it. Mr. McLaughlin, did you have a comment?
Yes, I apologize for the interruption. In response to Mr. Ron's question, some language that Mr. Ron or Mr. Dunham could propose would be on page 3, where it recommends approval of the parking variance subject to 2 conditions. On the second condition, where it reads, the approved variance is to allow a 23 parking space reduction from 99 parking spaces to 76 spaces for senior housing, would restrict the building, the parking variance on this building to senior housing. So the way the board would do that in terms of Robert's rules, and I'll ask Jill to help me with this, but one would make a motion to add those 3 words for senior housing. The board would vote on it. If it failed, then that would become part of the main motion. If it failed, then it wouldn't be part of the motion. If it passes, then it would become part of the main motion. It just would be important that when you vote on the main motion, that the board knew where you stood. Thank you.
Thank you. I guess I'll ask, are there any other questions of any of the board members? Or Mr. Ron, have you made a motion?
Yes, Mr. Chair, I would like to put a motion on the floor, and that is to amend Department Recommendation number 2 on page 3 of the staff packet to read, the approved variance is to allow a 23 parking space reduction from 99 parking spaces to 76 parking spaces for senior housing.
Thank you, Mr. Ron. Mr. Patrick, you've indicated you would second that motion to the amendment.
I do.
Thank you, Mr. Ron. Mr. Patrick, Mr. Ron, care to speak any more to that motion?
I don't, Mr. Chair, but I'd be happy to answer any questions other board members have.
Thank you. Ms. Williams.
I wonder if it would be appropriate to ask the applicant, and Mr. Robinson, if they support adding the language for senior housing to condition 2 before we vote on it.
Would you like to ask him that question?
Yes, I would.
Okay. Mr. Robinson.
Can I answer a question with a question?
Well, why don't you answer the question and we'll see if that.
I think that our intent is to build senior housing. It's designed as senior housing. The building would be different if it was not senior housing. So I have no objection. My one sort of question back is in the event that code changes and 40 years from now, because that's the period of restriction that we're initially putting on it by our funders, likely we would have it permanent. I guess I won't be concerned about it in 40 years, but somebody else may be. What happens then? Is it just handled administratively? Well, it recognizes the code has changed. You therefore meet it. But otherwise, to move on, that's the intent of our development. So, I guess I could also say we'll deal with it in 40 years.
Well, it must be getting late. You lost me on the question you were asking. Are you saying if you have a change of use after 40 years?
I guess I'm going back to staff's and some of your comments that had to do with in the event that the code as proposed is adopted in Eagle River, and therefore we meet by right for a residential use regardless of what the restriction is. Not that we're going to change it, but if down the road, I'm almost curious what happens.
My interpretation would be if the code changes and you meet those standards, you have this variance in place, but if the parking calcs reduce, then the change in use would allow it. I mean, as long as you meet those parking standards, you're fine.
Just curious, but no, thank you. We would have no objection to that language.
Are there any other comments on the motion? My one comment is I appreciate, Ms. Williams, you asking Mr. Robinson the question, but I don't, and I appreciate him offering his answer, but that doesn't weigh into my decision on voting for the amendment, which I intend to support. Are there any other comments regarding the motion to amend? Please vote on the motion to amend. That motion passes by a vote of 7-0. We are now on to our main motion. Is there further discussion on the main motion? Anyone else wishing to discuss? If not, please vote. That motion passes by a vote of 7-0. For the record, every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. That is our last case of this evening, which brings us to reports. I have no reports. I do like to, would ask the question, Mr. McLaughlin, what we've got for cases for next month?
It's a light load. I came unprepared for that question, but I think there are only maybe 3 variances submitted for next month's.
Thank you. Light load is a good answer. You don't have to go into any more detail than that. And is there anyone from the board that knows they will be gone next month? Ms. Williams?
Yes, despite my self-imposed boycott on weddings, I've been duped into going to yet another one. So I unfortunately will be out of town.
What's the date?
Mr. Vick? Oh, the 13th?
I will not be here.
Mr. Patrick will not be here.
I will be in Canada.
All right, so we are at 7. Anyone else? Does anyone have any comments this evening? Mr. Dunham? Ms. Denny? Mr. Patrick? Mr. Vig? Ms. Williams? Mr. Ron? If not, we are adjourned.